But please state your name, whom you represent, and you have 3 minutes, and you have the floor. Thank you, Ms. Bainey.
Thank you, Mr. Chairman. Mr. Chairman and member of the committee. My name is Caitlin Bainey, and I am grateful for this opportunity to testify on behalf of the Equal Justice Center. I am a civil rights and immigration lawyer at the Equal Justice Center, which is a nonprofit law firm in Texas. And I want to talk to you today about how wrong-headed it is for Texas localities to cooperate with immigration enforcement, not only because it undermines public safety when community members are afraid to call the police, but also because ICE operates with no regard for the U.S. Constitution, and local compliance with its voluntary requests would impose high legal and financial costs on counties, jails, and sheriffs across the state. The Priorities Enforcement Program is unlawful. Immigration detainers, which were a central fixture of the former Secure Communities program, are routinely issued under PEP and are not a legally valid basis to detain individuals. Jails are constitutionally required to have either probable cause or a warrant to detain a person after they would otherwise be released, and an ICE detainer request constitutes neither. Detainer requests include no specific factual allegations that would support probable cause, nor any separate judicial finding of probable cause. These requests are nothing more than a single sheet of paper faxed by ICE to the jail with a few boxes checked. Since ICE detainer requests are voluntary and per se unconstitutional, for the Texas Legislature to require that localities comply with detainer requests is akin to forcibly placing those counties and jails on a legal chopping block. When local jails honor these unlawful detainer requests, they necessarily violate the Fourth Amendment because there is no legal basis justifying continued detention. Scores of local jails, counties, and sheriffs across the U.S. are embroiled in litigation over their enforcement of ICE holds, and they are losing. Plaintiffs, some of whom are U.S. citizens who were subjected to these unlawful holds, have successfully sued localities or settled cases in the First and Third Circuit courts, as well as federal courts in Oregon, Nebraska, Illinois, California, Colorado, New York, and Utah. Notably, ICE refuses to indemnify localities for liability in these lawsuits. We know that localities in Texas are sure to be subject to this kind of litigation because Dallas County already is. Sheriff Valdez and the Dallas County have been sued twice in the past 6 months over Dallas County's compliance with ICE detainer requests. At this point, with constitutional claims against localities being upheld across the country, it doesn't take much for someone who is so inclined to file suit here in Texas. Lastly, I want to note how incredibly expensive it is to comply with these unlawful requests. ICE holds disincentivize individuals from posting bond and also effectively eliminate non-jail punishments that could be offered by the prosecution or judge. An individual has no incentive to post bond only to then be arrested by ICE, in the same way that it doesn't make sense for a judge to order community service or probation for someone who's headed straight into immigration detention. ICE holds artificially drive up jail populations, which cost counties across Texas nearly $4 million just last month. Ultimately, mandatory local cooperation with ICE comes at too high a price for Texas. Thank you.
Thank you, Ms. Bainey.